always get the question, have I won every single case that I've tried? And of course the answer is no. No lawyer has won every single case that that person has tried. In fact, F. Lee Bailey, in a lot of his books, talks about cases that he lost and the reasons that he felt he shouldn't have lost. I will say this, though. The large percentage of the time that in the cases that don't win are not because of the evidence. A lot of times it's simply because the client screwed up and the client didn't do certain things which the person had to do to win the case. And that happens, people, not so much recently, but in the early years of doing this, I do recall clients that just simply did the opposite of what they were supposed to do. So today I'd like to talk about how you as a client can potentially cause yourself to lose the case and how to avoid doing that. There are 5 essential reasons how or why clients screw up their case. Number 1, they talked about the case in writing somewhere. Really, really bad idea. In fact, we tell each and every one of our clients, do not discuss the case with anyone except maybe the person's spouse. That's it. When you talk about the case to someone else, that is no longer privileged communication, and anything you say, mark my words, can and will be used against you in a court of law. What really bugs me are clients who put their thoughts and feelings in writing. We once had a client who was communicating with coworkers about what she thought of her boss. And she claimed she was in a hostile work environment based on sexual harassment. But what she was talking to with her coworkers had nothing to do with that. It was about how the manager was mean, he was disorganized, he belittled her work, he was not a good manager. While these things might be a way to vent, if they have nothing to do with sexual harassment, the company gets a hold of those emails. And the company shows them to the judge. And the company says, Your Honor, this person didn't have a problem with sexual harassment. This person didn't like the manager because of these reasons, which are counter to the claim. Similarly, someone put something on Facebook about the case. One of the first things defense lawyers do now is check everybody out who's suing on Facebook and Twitter. Never talk about the case to anyone. Certainly never do that in writing. That's number 1. The second reason people cause themselves to lose in the case is they didn't get a lawyer soon enough. And I've talked about this in other podcasts, the need to complain at the right time, the need to follow the deadlines. And if you miss a deadline, you lose. And people, they lose their case before they even meet me. And when they meet me, I tell them, sorry, you've already lost the case because you didn't file on time, and there's nothing we can do about it. Number 3, the third thing that causes clients to lose their case is in the course of a trial or a deposition, there's going to be a key event. For example, a key conversation that happens. Someone says, for example, I went into my boss's office and I complained about gender discrimination. I complained about sexual orientation discrimination. And right after that conversation, my supervisor started being mean to me and belittling my work and things like that. And what happens is then the case goes to trial. And the person's account of that conversation is different than what they told us it was when we signed up the case. If you have a case and that case depends on conversations, or depends on certain events that you say happened, if the client cannot hold up on cross-examination to those events, that means the preponderance of evidence is those events did not occur, and the plaintiff will lose. And as I've said in other of these podcasts, to win a case, a judge and a jury have to like you. They have to believe you. They have to find you credible. They have to find you sympathetic. If they don't, it doesn't matter how bad your boss was or how mean your manager or the company is. You lose. That's critical. That's number 3. Number 4, I've also talked about this on other podcasts, but it's a reason that people don't prevail. The complaints that they had, that I told them, put this in writing, they never did. And generally speaking, if you have a complaint and there's bad stuff that's going on at work and you don't complain about it, and certainly if you don't complain about it in writing, what a judge is going to find is that there's really a gigantic question on how bad this thing was. Why didn't the plaintiff complain about the thing in writing? That's number 4. Number 5 is probably my favorite. I mean, this probably happens once in 100 cases, but for that 1% of the time, it is a reason to lose, and the client should lose. And I call it the failure to cooperate with the lawyer during the case. Perfect example. We send out a evidence table for the clients, for each client to fill out and complete. And what we tell the client in that table is, tell me what documents you think we need that your company may have that would demonstrate retaliation against you. Or tell me witnesses who we say, or who you say, will corroborate your claims so that we can interview them. He chooses to do this. Instead, he'll send back some rambling email about how he didn't like the mediation and it wasn't fair, and why did he only get this offer, and oh my God, the world is crumbling down because I couldn't get the defendant at an early mediation to pay him $5 million, okay? And then we explain to the client, look, to beef up the value of this case, you need more evidence, and the time for that is in discovery, and we need your cooperation. Do you want to win the case or not? If you would like to win the case, you need to cooperate with my office. You have to complete the tables. You have to be available for phone calls. This is the thing.